The events pose, in my opinion, the most serious threat to global security of the 21st century to date, so far. But they're also a critical test for international justice. One of the key factors, in my opinion, probably the most important factor for the success of international justice, is its procedures and the information and evidence on which its decisions are based. The crime of aggression has a very distinct definition: bombardment, invasion, etc., in terms of the act of aggression. And to then be prosecutable as a crime, it focuses on the individual element, the person or people who are initiating, preparing, and implementing effectively those acts. The key issue, I think, here, the key question, if this does come up, will be the leadership element. Is it in line with the Rome Statute definition, those who direct or control the state, or is it more in the line of the shape or influence, which potentially could extend to people outside the more military political hierarchy, perhaps more in the business sector and other influential sectors?
This paragraph basically refers to human persons. And bear in mind that the only thing that these human persons need to have undergone in order to qualify as victims is to have suffered harm. In the situation of Ukraine, if it can be established that the attacks that led to this harm were unlawful and constitutive of war crimes or crimes against humanity, this category of legal persons would be able of encompassing, for example, the maternity ward that was bombarded a couple of weeks ago, or the hospitals that have suffered a similar fate, the Ivankiv Museum near Kiev, the Arkhip Quincy Museum in Mariupol that was allegedly destroyed or partially destroyed yesterday, Babi Yar as a historical monument, schools that have been destroyed, and other institutions such as research center, orphanages, and arguably also zoos and animal shelters. The LRBs can make opening and closing statements at court. They can obtain access to evidence and to the confidential record of the case. They can question witnesses, experts, and the accused. They can challenge and lead evidence, and they can make submissions on sentencing. Through Article 68.3 and through all these avenues, what the court is trying to do is to make sure that victims are given a voice and that they do not become passive viewers of the trial. There is no guarantee, and actually very far from it, that they will be considered a case victim and that they will ever receive any reparations if their case doesn't follow through. The possibility, however, of them being considered victims and being taken into account does exist.